Good evening, everyone. Today is Tuesday, June 17th, 2025, and this is a regular meeting of the Asbury Park Zoning Board of Adjustment. Vice Chairman Scully, can you please call this meeting to order?
Certainly. This meeting is being held in compliance with the Open Public Meeting Act, Chapter 231, Public Law 1975. Adequate notice of this meeting has been provided to the Coaster and the Asbury Park Press by publication of the annual meeting notice and posted on the Municipal Building Board and municipal website. All notices are on file with the board secretary. Official action may be taken on the following matters before this board. This meeting is being recorded by APTV, and I please ask everybody to silence their cell phones. Roll call, please.
Wendy Glassman.
Here.
Daniel Harris.
Here.
Russell Lewis.
Here.
Jill Potter.
Here.
Natalie Passerini.
Here.
JJ Hall.
Here.
Vice Chair Scully.
Here.
And Chairman Avalone is recused.
Okay, so the first thing is the resolution for 807 Summerfield Avenue.
Yes.
I know there's some emails
Yeah,
back and
there's-
forth.
you
Do
got
you
the-
want to catch us up?
I
Jeff?
sent you mine and I sent you Donna's. Tell me what you want to do.
Right. So I had expressed concern with Donna's version. I think it was the fifth whereas clause, that it didn't pertain to the actual application
Okay.
that we heard testimony on, and that the language was a little broader and could be interpreted that it applies to any application that's under the redevelopment plan.
Okay. Yeah, that one
Again,
sentence at the end.
correct. That one sentence at the
The other changes
end.
were fine that they,
All the other changes were fine.
Okay.
I just, in my opinion, I felt that it broadened it beyond just the application that we heard, and that interpretation could be applied to any application outside or within the redevelopment plan. Just my opinion. I'm open to discussion. If anybody else has something else, or if somebody would like to make a motion on what resolution.
define it narrowly. Don't define it broadly, define it narrowly.
That's my question.
Make it narrow.
So we have two resolutions. We have the version of Jack's,
Yeah.
which is, the language is in that fifth whereas clause is specific to the application that was in front of us.
Yeah.
And then we have Donna's, which, again, my opinion, expanded the broadness of the resolution.
Yeah, that, other than that, everything else that Donna offered was fine with me.
Correct, yeah, I agree.
Can we rephrase that last sentence
Well,
then?
we could strike it and then just leave everything else that Donna put in. You can do whatever you like. I mean,
Right.
it's your choice.
We can go back to Jack's language, which, Jack, can you just read your language? Because I think you
Okay,
said something to
that's
the
what I'm
effect
trying to
of.
figure out which one is which here. Okay, I put Donna testified, no.
We were talking about the,
Yeah, I think the language that came into question was,
now therefore be it resolved.
no, up further. There's a paragraph that you changed. It says, I talked about your testimony, and then you added in, like the second line from the bottom, however, any deviation from the applicable requirements of the redevelopment plan, such as parking, would require a variance which could only be granted by the planning board as part of the application for site plan approval. A parking variance was required for the proposed use. Therefore, the plan by the city planning board was required. So you struck out that.
That's what's right.
Yeah, so, other than, everything from the however, after, the however broadens the scope, in my opinion, as to what you did,
I agree.
okay? So the rest of it is stricken anyway, and the back end, so that phrase, period, after involve the alteration of the site review and approval of site plan is not required, period, end. Then you take out the rest of that section, as Donna already struck out more of it, and then now the therefore, that's fine, I'm okay with the therefore be it resolved
Right,
clause, that Donna added in, that seems appropriate,
right,
so.
okay.
We
All
can,
right.
we'll take Donna's version, I'll clean it up, we won't pass it, and we'll pass it for tonight with the red markings, but I'll omit
Clean it
the
up.
phrase. But we'll omit on page 1 at the bottom, after the word require, and the second line from the bottom, However, any deviation from the applicable requirements of the redevelopment plan, such as parking, would require a variance which could only be granted by the planning board as part of an application for site plan approval. And then she had already stricken out the rest of that
But
sentence.
that was my testimony.
Yeah, but that's,
That was my testimony.
okay, well then,
The paragraph is saying what I testified as, to.
Okay.
Testified.
okay, then we should strike her testimony and not put it in there, because you're broadening the scope of the appeal. And my job is to keep the appeal as narrowly defined as possible, so that if any different set of facts comes in, the zoning board can interpret it differently. You're only dealing with this very narrow issue that was presented before us. If you broaden the scope if you start going into other things, then it can be applied on a more broader base as precedent. And I don't think that's what you want. I think what you want is to narrowly define your decision to only deal with what Andy's application presented.
Correct. That was my position, is
Yeah.
that the resolution should only reflect
Yes.
that application. and
I'd
it-
rather it be constrictive as opposed to expansive, because if we start talking about other things, I'd rather them stand on their own in the future. So
Right.
that this way the board, Donna nor the internal staff is hamstrung by anything other than this one narrow case.
Right, the same set of facts.
Yeah,
So then the now therefore should go back to the original wording.
let's see. All right, site plan is not required, all right?
This is a global
Yeah,
statement,
I would
not-
leave that alone, because that's pretty innocuous, it's fairly straightforward. That a permitted non-residential use with no changes to the site or proposed, period. That makes sense. That's okay. That still narrowly defines what's been going on here.
Jack, do we have to pass this tonight, or can you?
No.
Can you?
No.
Can you send
it's your
around
file.
a?
Do you mind if we carry it?
So why don't we send around a clean copy,
Yeah,
and so everybody can see it?
okay.
All right, so we'll carry
Okay, we'll
that.
table it for now. We'll carry it to the next meeting.
Yeah,
Okay.
this way, I
And
don't
I'll
want
talk to
anybody
Donna. We'll
to,
refine the language that we can both live with.
yeah, and I don't want anybody to approve
Okay.
something or vote for something that they
Yeah, that
haven't
makes sense.
seen.
Makes sense. Yeah, we've got time, and Andy doesn't mind, so we're
Is a
good.
motion to table then?
Yeah, motion to table that. So I'll make a motion to table that.
Second.
Dan Harris, second.
All in favor?
Aye.
Any opposed? Ayes have it. Okay, thank
Okay.
you.
So next application is 301 8th Avenue, Unit 3. Mr. Karas, you want to give us a brief summary of how we got to this point?
It's been a little while.
It
I better
has.
swear in Donna in case she disagrees. Please raise your right hand. You swear and solemnly swear affirm the testimony you have given this matter, the truth, the whole truth, and nothing but the truth.
I do.
Well, this way you can speak if you have.
Donna Miller, board planning.
Thank you.
Do we have to get additional people on?
No, okay, let's for the record. Jill, you viewed the video of this? Okay. Back when? And
Yes.
you submitted an affidavit or
Yeah. So
certification,
it was after the
correct?
January 28th, she missed that meeting, but she then watched it because it was
Yeah,
coming back.
right.
but
So
then it was-
if
yeah.
we don't have the certification, I'll put it in. Was everybody else here for the January meeting?
Yep.
I believe
Yes. Okay, so then everybody, we have a complete board, everyone is eligible, all 7 members.
The only person you're missing is Tim Slick, who's no longer with us.
Right, and Tim's gone, okay. All right, go right ahead.
If I may, Andrew Karras, on behalf of Karen May, Michelle Nielsen. Here with our property, 301 8th Ave, Unit 3, Asbury Park, Block 4301, Lot 6.03. Just give the board a little reminder of what this application is about. It's a bifurcated application. We're only here for an interpretation tonight, depending upon what the board does. We'll determine whether or not we have to come back at a later time for a D2 variance. Property is a multifamily piece of property. It's a 7-unit condominium building located within the R2 residential zone. The reason we're here is to determine whether or not a roof deck that is, based upon the evidence that we claim reflects the state of the property, needs a D2 variance to be utilized by my client. The evidence that was presented shows that back in July of 2002, a certificate of zoning compliance was issued by the Board of Adjustment. here in Asbury Park, establishing this structure, the 7-unit structure, as a valid non-conforming use. We take the position that based upon that, if there is an existing roof deck at that time, that it continues today, my client has the right to utilize it, and the mere adding of new decking and railing does not change that. So we take the position that it is not an expansion of a non-conforming use because of the existence of the door that is there and the use of that property, that roof. Number two, there's another consideration for the board. There is a ordinance within the zoning code here in Asbury Park, section 3-73.12, that states as follows. Multifamily residences in any zone shall, one, provide open space for residents that constitutes at least 30% of the lot area. The open space requirement may be met through the means of common interior recreation areas, balconies, roof decks, or terraces located on the same premises. So as a second reason why a D2 variance is not required within the zoning code, any multi-family residence in any zone, not restricted to particular zones that allow for multifamilies, but any zone, must provide the residents with at least 30% of open space on the lot area. That can include, as indicated specifically within this section, roof decks. I'm going to provide testimony tonight, some additional testimony. Number one, as to the percentage of area that is dedicated to the residents at this particular piece of property, that is way under 30%. I'm also going to present additional testimony from neighbors that this roof deck had existed back from 2002, 2004, and historically that's been the utilization of this property. With that being said, I have basically just a few witnesses tonight. Will be very quickly in terms of testimony. Right. You can come sit right next to me.
Okay. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record and spell it.
Elaine Lipani, Lipani.
Thank you.
Ma'am, can you please tell me your current address?
301 8th Ave, Unit 4.
And when, are you the owner of that unit?
Yes, my husband and I are.
When did you purchase that unit?
In 2005.
And when you purchased the unit in 2005, you obviously viewed the premises before you purchased it, am I correct?
Yes,
And you had the opportunity to take a walk around the premises and see what was situated on the outside within the premises, am I correct?
yes,
In terms of the roof area, did you have an opportunity at that time to view it?
yes, I have.
And what was up there?
It was a roof deck, and people would frequently go out there and sun themselves.
What I'm going to do is I'm going to show you a document, and I think we're at page 7. And it indicates that it's a listing for the property, and indicates that the property sold in 2002, November 25, 2002. On the second page is a photograph. I want you to take a look at that. Pass this around. You see what's on the second page? You recognize
Harris.
that picture?
Mr. Karas, I'm sorry, do we have that in our, is that in our packet? Okay.
I'll wait for everybody.
Yes.
Y'all have it? Looking at page 2, you recognize what's in that photograph.
Yes, I do.
And what is in that photograph?
Well, if you're asking me about what we're speaking about, to the right-hand side, along Webb, you'll see a door, and that's where people would enter and exit onto that flat roof deck that was there that extended onto the front, onto 8th Ave.
So is that the premises at 301 8th Ave?
Yes, it is.
And that's a building that, when you purchased your premises, is that the way it looked?
Yes,
And was that door there at that particular
Oh,
time?
yes. That was one of the selling points that, we could have a deck and we could do the same thing.
And at any point in time, did you ever see anybody utilizing that roof deck?
Yes, I had.
Okay, and was that over the years as you occupied the premises?
Yes, over the past 20 years, on and off, people would be using it primarily for sunning themselves.
No further questions. Thank you.
You're welcome.
Could someone just point out which is supposed to be a door?
Go to the second page.
I still don't see which is supposed to be.
Looking
a
at the
door.
roof deck, did
Ah, okay.
On the
you
right.
see it?
Uh-huh.
Okay, thank you.
Wait, I have some
Yes.
questions.
Hold on. It's not that easy.
I never did this before. I'm like,
Just about out of it.
sorry.
So, I apologize, how do you say your last name?
Lapani.
Lapani, Ms. Lapani. So you state that you saw people out there in the condition that it is with no railing?
Yes. There
And they
was
were-
never a railing.
Okay.
Well, in the past 20 years, there's never been a railing.
And when you saw people out there, were these people just congregating, or were these people out there to fix the roof or repair
Oh, no,
people?
they were out there sitting on towels, just sunning themselves.
Okay.
One or two people. It wasn't a huge gathering.
Okay.
That's prior to you buying the house.
Excuse me?
That was prior to you buying the house, right? Purchasing the property.
Well, I didn't see it prior, but once we purchased, over the past 20 years, we had seen people out there on occasion.
Any purchased in 2005?
Yes, we looked at it in 2004, and we purchased in May of 2005.
So after you purchased it, then you saw people on the roof.
Excuse me?
After you purchased it.
Oh,
then
yes,
you saw
yes, I'm
people on
sorry,
the roof,
yes.
Not before you purchased.
Oh, no.
Okay, thank you.
You're welcome.
Do you recall the last time you saw someone out there using it for personal use?
No, I can't say. I can't give an exact time.
Okay.
Did you mention earlier that when you were either looking or first bought, that you did see the railings on there?
No, there were never railings there.
Oh, there was never railings?
Never a
Okay,
railing there as far as
understand.
yes.
So this is for the application, or the interpretation that we have before us is for Unit 3. And you live in Unit.
Unit 4, which is right next door. It's
My
divided
question
into,
Is this door a door that all owners
no,
use?
it's on
Or
the
is
second
this
floor.
part of-
It's on the
part of
second
Unit
floor.
3?
Unit 3.
So it's not a common, it is not a common door?
No.
Correct.
Okay, I don't know how to ask this question, but the ordinance that you read to us applies to common areas or private areas?
It was,
The ordinance that I read says it shall provide open space for residents that constitute at least 30% of the lot area. It may be through common interior recreation areas, comma, balconies, comma, roof decks or terraces located in the same premises. So it doesn't mean it has to be comma.
But it doesn't presume, this ordinance, I think, relates to the use by all of the owners in
That's not what
that
it says.
building. I'm asking because it's a question for me that I'm not so sure if the only way you can get to this area is through someone's private property. I'm not even sure if that ordinance is relevant to this discussion.
Well, the ordinance says what it says, that multifamily residences of any zone have to provide at least 30% open space for the residents, and it can be met through various ways. It doesn't say that each particular area of open space has to be for all the residents. It says it can be met through common interior recreation areas, comma, balconies, comma, roof decks or terraces. So it could be through individual terraces for individual tenants. You look at it all together and you add it up. That's what it says.
And it's not meant to, the way I'm hearing this is it's not meant to be either for everybody to use. It could be 10% is for this?
That's,
We don't know that.
I'm asking.
but you add all together,
Okay.
if there are common areas, you add that to the roof decks, to the terraces.
Would the ordinance apply to a non-conforming,
Applies to all multifamily, yeah,
all whether they're conforming or not conforming?
yeah. Just like the parking required is for all uses, whether they're conforming or not.
Do you know what the coverage is on the first floor for the
We're
first
gonna
floor
have
porch?
testimonials.
So, are you guys still asking questions?
Excuse me.
Well, when you're done.
Thank you, sir. When you purchased it, did you consider this a deck? When you purchased it, did you consider it a deck, being it didn't have any railings or anything around it?
I considered it a deck. I didn't know the difference that whether you needed a railing or not. I do realize that you need one, but at the time I didn't.
I can't hear you. You're mumbling.
I'm sorry. No, I didn't realize that it didn't have a railing and that, but I saw it as a deck. I didn't think that it's a deck without a railing
Did you consider the
It's a
safety
deck,
aspect?
Not just a roof.
because there was a door and people were out there sunning themselves. So I assumed,
Not just a Tar Beach situation.
no, because when we purchased, they had told us that there were several units for sale. When we bought in 2004, it had just recently been purchased by a contractor, and all these units were for sale at the time when we had come in. And one of them was Unit 3 that had a deck.
If I may continue now.
So I didn't think that it didn't have a railing, I just knew that it had a deck.
Did you take into consideration safety? Would it
No,
have
I didn't
without a
think of that.
railing?
We weren't interested because we bought a unit, the only one that was renovated, which was Unit 3, so that was our sell point. So it didn't matter that they had a deck or not. We were not interested because it wasn't renovated, if that makes sense.
Can I follow up?
Yeah, go ahead.
When you purchased the property, did you have an opportunity to take a look at the master deed?
Yes,
And you reviewed the master deed?
yes,
Let me show you what's been marked already as A5, dated August 24, 2004. Does that look to you like the master deed?
yes. I haven't looked at it in years, but yes.
Okay, and it reflects this particular property at 301 8th Ave, correct? When you purchased the property, did you have an opportunity to review and read through the master deed?
Yes,
And did you have an opportunity to look at the different diagrams for the various apartments?
yes, they were all enclosed.
And looking at apartment 3 in that master deed, am I correct, it reflects on there that 500 square foot roof deck?
Yes,
And it indicates description as a roof deck, correct?
correct, along Webb and 8th.
I have some questions, if you don't mind.
I'm done.
Since you're testifying as to the contents of the master deed, are you aware whether or not the city was aware that that master deed contained decks? Do you have any personal knowledge of that?
I don't understand what you
The
mean.
question is, you testified as to what the contents of the master deed
Right,
are. Are you aware if the city was aware of the
no,
contents of the master deed?
no, we didn't, no. I was,
Are you aware whether or not the city gave permission in any way, shape, or form to file that master deed?
no, but I had no,
No buts. If you give me a but, I'm gonna keep asking questions.
okay.
Okay,
No,
okay, that's fine. Okay. All right. Are you aware of the surface of this so-called deck?
no, I've never been on it.
So you wouldn't know if it's a pitched roof or a deck personally, because you've not seen it personally? Other than the fact that people are sitting out there?
Correct, but it looked flat from looking at it from the street, it looked flat to me.
You're looking up, over the
Correct.
top.
Correct.
Okay. And do you know if it has a deck surface or a tar paper roof? or
No
shingles?
idea.
No idea, okay. All right, okay.
Any further questions? No? Thank you for your testimony.
Public.
Oh, public.
Public have any questions of the witness?
Anybody in the public have any questions? No?
Okay, thank you.
Thank you.
Thank you.
Next, I have my client, Karen May.
So please raise your right hand. You solemnly swear or affirm that the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
Please state your name for the record.
Karen May, M-A-Y.
Thank you, Karen.
Karen, am I correct that you are one of the owners of 301 8th Ave, Unit 3?
Yes.
I want to ask you about the areas that are utilized exterior for the tenants and also interior. Are there any common interior areas within the premises that are utilized in a sense as open space for the tenants that are available for all the tenants to use within the building?
Within the building is only hallways and staircases.
On the exterior of the building, are there areas outside that are utilized in a sense open space for the tenants?
There's the main floor front porch, and there's a patio in the back.
And the main floor front porch, do you know the size of that?
It's roughly 10 by 25, maybe?
Okay, and what about the patio that we mentioned?
Oh, the patio is, I have that somewhere, it's roughly, I think it was 40 by 35 or 40 by about 25, 30.
Okay, so am I correct, rounded out, the porch is around 250 square feet and the patio is around 1,000 square feet?
Correct.
The size of the property, am I correct that it is 50 by 150?
I believe so.
That's 7,500 square feet, am I correct?
Correct.
As the owner of the property, when you purchased, let me ask you this, when did you purchase the property?
We closed on the property in March of 2021.
And was there a door leading to the roof? at
Yes.
that time? Has that door, since you owned it, always been there?
Yes.
All the questions I have.
Good evening, Ms. May. The door that leads out to this, has it always been functional?
Yes.
Okay.
It's an original door, as best I could tell.
Okay. When you were looking at the building for purchase, did you notice anybody using this area as a recreational deck, so to speak?
It was winter time, so no.
And when you purchased it, your understanding was that, what was your understanding of that area?
That was a deck for as part of our unit.
Okay. And
It's in the master deed. We talked to the management company, and that is a deck as part of Unit 3.
Okay. And what's the material that's on the area right now?
It's an EPDM, is that the right initials for it? It's a white membrane, EPDM surface, and it's basically flat. It's got a slight pitch to it just for rainwater to get off of it, but it is that white EPDM. It's not shingles, it's not tar paper, it's a white
Okay.
flat surface.
Do we have any pictures of the existing deck? Like close pictures of what we're talking about, so we can get it, like a close picture of the door and the door jamb and what we're looking at for the floor. It seems we're really.
A6.
A6? Is that what A6 is?
It might be.
Is that this? I can back that.
But that's not really giving us a detail of what we can,
Yeah.
I'm trying to determine what the floor looks like, and this is not helping me.
Can I ask, so you applied for a zoning permit in 2024 to convert the porch roof to a fiberglass deck?
To redo the surface of it. It hasn't been touched in some time, so to, first of all, most importantly, put a railing on it, and to add a new surface for the top
Why
of
is that
it.
most important to put a railing on it? If you've been there for 20 years without a railing.
We have not been there
Oh,
for
no.
20
I'm
years,
sorry,
we've been there since
no, I'm sorry,
2021.
21.
4 years.
I apologize. So why was it important when you bought to have a railing?
It had a C on it, to me, we have a dog, if the dog wants to go out there.
Construction inspector said
Okay.
railing.
We have a dog, and for the dog to go outside and be able to be on the deck, you want to have a railing, because the dog's not smart enough to not fall over the edge.
Yeah, some people aren't either, but You may hang with a better crowd than I do.
You never know, but I just, if I think of a Victorian house, a Victorian house has second floor decks and porches and their railing. It's a part of the look and feel of the unit. And so having that new surface and upgrading that, and then part of what we would do is add a railing to that.
And so is it the surface of the porch roof that, is it in bad condition, or why change it to a fiberglass deck?
That's what our contractor recommended, would to have the fiberglass deck rather than putting in, say a wood or some other material.
But is there anything wrong with what's there now?
I don't believe so, it's just, we were just gonna put in new flooring.
Upgrade it?
Upgrade it, yeah.
Did you use it? Did you go out regularly? Did you,
I wouldn't say we go out there regularly, but we have been out there.
how often?
No, just a couple of times over the years. We were doing renovations, so we weren't there 100% of the time. And in the couple of summers that we've had there, we haven't been out there that often, but a handful of times.
So to Russell's point, I'm still not certain what the material is. Is it like a flat roof type material that's up there?
It's a roofing, EPDM is a roofing.
Is that what that
membrane.
is?
It's a roofing membrane.
It's a
Yeah,
roofing membrane.
Like a waterproofing membrane?
Yeah.
It's like a John Mansville roofing membrane. Yeah.
Okay. So it's not meant to be
walked on.
To be walked on.
It's not decking, it's roofing?
It's roofing,
I just wanted.
yes, that's what that is. That's right. Andy would know, he's a builder.
It's
Right,
a
but
roofing membrane.
it's a membrane.
It's not roofing in and of itself. Ordinarily, you put that as a barrier.
Okay.
Is it wood? Is it wood?
No, it's not. No.
And is it a composite, any type of composite? Okay, well, I'm
It's a
sorry.
manufacturing material.
It's not a wood composite.
But it's
No,
not a wood
It's
composite.
a manufacturing material and
I
it
mean,
provides for waterproofing.
I'm just up here looking at the definition of a deck, and it says, in the context of a house, a deck is a flat elevated outdoor platform typically made of wood or composite material that extends from the house and serves as an outdoor living space, often used for relaxation or entertaining and dining. Did any of this come into play when you purchased the house, purchased the apartment?
In terms of
What you wanted to do with it?
when you purchased it, was your intent to utilize it as a deck?
yes,
You indicated you were upgrading the property, am I correct?
Yes,
And
yes.
you've done that over time?
yes.
And was it always your intent to upgrade that exterior area to put on better decking?
Yes, that was the last phase.
But
Or
it's-
is the last phase.
But as I understand what you just said before, it's not putting on better decking. You don't have any decking.
You don't have
The
any
material
deck.
that you have
You would need
is
that under the
roofing,
decking anyway.
is the under layer for a roof, not the under layer
You
for
would
a
need that
deck.
anyway.
I have a question on that, Mike. Is it the same surface that extends beyond that area and goes around? This is the surface?
In the
I'm looking
picture?
at page 2, it goes around, I assume this is web and this is 8?
Correct,
So is it the same surface here as it is over here?
yes.
Okay, so, okay.
Which
Yeah,
is
but
that,
the
Jim?
type of material you would need anyway, anything that you put over, you're gonna have an underlayment to make sure that it is waterproof. So that would have to be irrespective on that.
It's your job to determine, based on the evidence, what you feel it is. You interpret it the way you see fit. Okay.
Is it slanted?
Yes.
Partially slanted.
Testified that it
There's
has-
there's a very, very slight pitch to it for water to
For water to run
Because
off?
when it rains, yeah, you would do that with any deck, is you have to have, you want to have a slight pitch.
Or you have
So
to
the
have
water
planks where the
goes
water,
away from the house and.
or you
the
have
water-
planks where the water goes through. You can have a deck and have planks there and the water just goes through the planks and it will be straight.
Okay.
Okay,
Right,
Yeah, you could
Yeah.
have things that absorb it and remove some water.
right.
right,
I mean,
yeah.
okay. Just trying to get a picture because the picture that I look at, it still looks like just the roof over top of the porch, which you want to convert into a deck.
Yeah, it's not shingles like what you see on the rest of the house.
Right.
Yeah.
Which there's no railing there. which if you had a deck that, you know,
It's unimproved, but it is, according to, again, the evidence that we present in my position, as my client's position, it's a deck, but it's unimproved, and we're looking to improve it.
Whether or not it's a deck or not, you're going to determine that. Garrison's going to tell you it's a deck. You'll determine whether it is or it isn't.
Well, you can walk on it. It's not like
I
it's just a
understand.
loose membrane and you're kind of like on a trampoline idea. It's,
One of my legal
Just-
secretaries lived there for 10 years back in the 1980s. I know the property.
okay, excellent. I didn't have this remembering then.
I don't know. I can't testify.
All right, any other questions for Ms. May? No? Anybody from the public have any questions
Do you have a
regarding?
question?
No, I guess not.
I pulled up this picture online and it's a lot clearer to see than this picture. It's a lot clearer. It also states here that that you purchased this with a board-approved plan. Is that the case? Was there a board-approved plan for it says walkout deck,
Well, there's a door, so you
Right.
would walk out onto the deck.
right?
And the board has approved, the board manages the master deed, and so.
You're talking
and then-
about
For the condo
The
board,
condo
yes,
association.
that's the condo
Okay.
association board.
Was there an approved plan by the board that you received?
It's in the master deed.
Which board are you
The master
referring to?
deed.
Planning,
The
zoning,
condo
or
board,
the?
their
No.
HOA.
The HOA.
Okay,
Yeah,
right.
the
That's all. I just
HOA
want to make sure we.
Yeah.
Yes, it's the master deed, so the HOA. And when we put together the plans for the renovations that we've done on the unit, that included doing this deck. And so that has been approved when we shared that with the board and the rest of the condo owners as well.
Are there two entry doors into your unit? And do you know if there were two units combined at one point?
When you say two entry doors, you mean, there's a door that goes out to this deck, and then
No,
there's
I
a
mean-
door from the hallway into the unit.
It's
No, I'm talking
Sorry.
about two entry doors from
There-
the
there-
hallway
When
into
we
your unit.
purchased, there was one door from the hallway into our unit.
And is that into the living room or is it into the hallway between the living room and the bedroom?
It's into a hallway.
There's no door into the living room that contains this bay window with the door. That's your living room, correct? Where the door is out to the deck?
Correct.
And there's no door into that unit?
From the hallway?
From the hallway?
No.
There's an old plan showing a door going in there, but that doesn't mean anything.
I've seen that, yes.
So they're combined at some point. I don't know if that's relevant, it's probably not.
Or they moved the door from being in the middle of the living room to being in the hallway, so that you walked into the hallway rather than to a living space, would be another possibility. It was when we bought it, it's where it currently is.
Okay.
Okay, any other questions?
Your own internal plans or your board plans, whatever you were just referring to, did you ever submit them to the city?
Yes. We had
For
permits to
approval?
do the interior work, and then we
No,
sent
no, no, not a construction plan. I don't know, if the association's planning documents or whatever. I understand that you went to seek approval for the construction, but,
Those don't normally get submitted with the zoning.
sorry?
Those don't normally get submitted
No.
for building.
But just checking, it was never submitted, okay,
to the
it's
city
not-
or to
yeah, it's not a
the
document.
HOA
It's- I'm
board?
just trying to understand. It's
Yeah,
not a
yeah.
document that the city would have been aware of and approved.
And
It was your
HOA
plans, it was the HOA's plans.
Master plan, I assume.
The master
The
deed.
master deed,
The-
floor plans, the city wouldn't be aware of those.
I can't say whether or
Right.
not the city is aware, back when the master deed was filed in
No.
2004. I can't say if the city was aware or not. I can say that the city did recognize this property back in 2002, July of 2002, as a valid non-conforming use, and our position is, let me finish before you start nodding your head. Our position is that it was deemed a valid non-conforming use. It was deemed a valid non-conforming use as what was there and what is existing.
You're saying the
No.
deck was there in
No,
2002?
That's a position that I'm taking.
Read the permit.
Yeah.
The permit doesn't say the deck exists, does it?
No, it says it is a valid, non-conforming, seven-family.
Yes, we know that. I was the guy who authored the
Yeah.
resolution.
But it doesn't go beyond that.
But we take the position, if it's, you don't parse out different portions. What is there was deemed as a valid, non-conforming use. What was existing at that
Wait a
time.
minute. 1 second.
But what was
That's
existing
not the
at,
permit history.
Let's see what the document says.
sorry, but
Let's see the
what was
document
existing
says.
at that time was just this membrane with no decking material, quote
Actually, no, the
unquote.
membrane came after 2002, according to the permit
So do
history.
we know what was there
Um,
at
Well,
that?
that's a testament I provided.
This is
back in
your
2000.
zoning permit, right?
Sorry, what's that,
No, no,
Jeff?
there was a resolution.
Resolution from, we already confirmed that it's a non-conforming use by the zoning.
That is
Yes,
correct.
but the zoning permit, that had nothing to do with decks.
Right.
The resolution authorized, saying that this was.
So there's a resolution acknowledging that it is a permitted, non-conforming use.
Absolutely, yeah, I
As a
drafted the
seven-unit-
resolution.
A 7-unit dwelling.
Yeah, it's a 7-unit dwelling.
And then you have the certificate of non-compliance that was issued that we marked as A2 in July of 2002.
Okay, I understand it's a valid non-conforming use, but as far as the deck is concerned, where does it say that that's a valid non-conforming use?
We take the position, two things. Number one, that whatever they deemed as valid, non-conforming at that time is valid and non-conforming.
No decks were ever discussed at that
I
hearing.
know- Well, what I'm saying is what was there, that we're taking that position. And number two, we're taking the position also that the permit that was issued in A4 gives credence to what was determined in 2002. It's consistent.
Which one are you talking about? Read from it.
What permit?
There wasn't a deck there
Bill-
back in, when I did that resolution.
If they-
There was a doorway, I will concede, but there wasn't
Which-
a constructed deck.
There is a doorway out onto that roof area.
Correct.
Right.
But that doesn't
And then in-
necessarily make it a deck.
In 2005, we're taking the position that based upon the evidence that we have, including the zoning permit that was issued and the master deed, there are two ways we're making the argument. Number one, that it is a valid deck based upon the master deed consistent with A4, the zoning permit. And let me finish.
Go ahead, well, I'm gonna finish, I'll
You may
respond.
disagree with me, that's the position we're
absolutely.
taking. And then number two, alternatively, that based upon the ordinances that we have existing now, that it has to be 30%, a minimum of 30% of your open space. We have two arguments that we're making.
Okay. But
You may disagree with me, but those are the arguments. I'm putting
First
forward.
argument is, I don't see what you're saying. I don't buy that. Okay. There's nothing in the record to prove that. Second argument, and equally important, okay? I understand the ordinance that you're quoting. You're gonna have to show us that how that ordinance trumps or supersedes the law on expansion of non-conforming uses. You have to show me by way of ordinance, case law, or statute, that section of the law overcomes the need for a D2 variance for an expansion of a non-conforming use.
I think by the language in and of itself that it says there, and it says multifamily is in any zone.
I get all of that, but that doesn't take into consideration a non-conforming use.
Of course, it says it.
Doesn't say a non-conforming use,
It says multifamily is in any zone.
okay, but this is a multifamily in any zone, but it doesn't speak of non-conforming uses that possibly are being expanded, and there's no necessity for a variance. You're gonna have to show me legally.
I'll do a memorandum to you of the law on it, but I can tell you right now, by the very language that you are reading in there, it doesn't say multifamily in zones that are zoned for
You're gonna have to do a
multifamily.
memo,
It
you're gonna have
says
to quote me
with-
statute, ordinance, or case.
Wait, wait, wait.
I
So
think
wanna-
you do
can
the
I
clear
just-
language of the ordinance.
I want to understand this,
that doesn't work for me.
What we're asking here. You're saying that section of the zoning code that requires multifamily dwellings to have open space has to be achieved regardless of any other requirement?
That's what it says.
No, it doesn't say regardless of any other requirement. It just says
Let's
you have
read
to
the
have open
ordinance.
space.
It says multifamily residences in any zone shall, not may,
Yeah.
shall provide open space for residents that constitutes at least 30% of the lot area.
And if
So
they
it's a-
don't, then you get a
wait,
C variance.
It's a requirement.
Do you have 30%?
That's one we have, that we have 7,500 square feet. There's testimony that you have 1,250 square feet of open space for the residents.
Where? Where?
That's the patio and the downstairs deck. That's 1,200.
How big is the deck?
Wait,
No.
that's not the only stuff we count.
Read it. That's what's.
I'm just saying, that's not
property.
the only stuff that counts.
You
Your
count
lawns.
on the property.
Yeah.
What is utilized as they define it in here.
Open space, yes,
No.
yard areas.
Right, there's a lawn.
patios.
No. That's
Yeah,
not-
yeah, I wrote
You
it
have to
down.
look at the definitional sections. It doesn't
did.
say your front lawn. There is no rear yard.
It says,
No.
yard areas.
Please don't interrupt.
You interrupted me
Please
5
don't
times already,
interrupt.
Andy.
It
I'm tired
doesn't-
of being told
All
that.
right, let's.
It doesn't-
let's-
I didn't get my question out. Can I ask
I
my
know.
question?
Yes, Donna, please finish your question, and we'll all
Why
be
would-
respectful and professional.
Is your premise that the requirement to provide open space more important than any other requirement in the code for uses? So multifamily use has to have open space. It also has to have parking. It needs to have side yard setbacks. It needs to have, such a building needs a certain amount of lot coverage or not so much lot coverage. Which one of those things is more important? Or are they all equal?
If
Are they
you're
all
not-
equal?
If, what is all equal?
All of the requirements in the
Well, I'm not talking
code
about
to
any
use.
other
I'm asking
requirements.
a question.
It
That's the
depends
question I'm
upon the
asking.
situation, and it depends upon the application that you're presenting.
Okay.
We're not presenting a parking application. It's not an issue of parking. It's not an issue of
No, I'm asking
what it
if all of the
says.
sections of the code
What
are
this says.
supposed to be
I'll read it
equally
again.
pro-
It
equally
says in
provided.
this particular section, open space.
Yes.
Multifamily residences in any zone shall provide open space for residents that constitute at least 30%. There are definitions of open space within the code, and when it defines open space, it talks about space that is set aside, dedicated, designated, or reserved for public or private use or enjoyment of the property of the occupants. Now, it also says area of land or water essentially unimproved, but here, when you look at this particular section, it doesn't reference unimproved. It references recreation areas that could be in the common area within the interior, balconies, roof decks, or terraces. So what it does is that not only the implication, the language of this ordinance is that the properties, multifamilies, must have dedicated space, designated reserved for the residents. It doesn't say simply impervious. It could easily have said, okay, it has to be impervious area, and that would be any green area. It doesn't. It's dedicated space for the tenants. and it
But do you really
defines it.
think it makes any sense to say that there's open space which is reserved for one
100%, because
one
that's what it
tenant.
says. That's what it says.
falls under this?
Yeah,
Why?
because that's what it says. It doesn't say.
It's not, it uses plural.
You're
It
right.
keeps saying residents with a plural. It keeps saying spaces. I mean,
But it
It's-
doesn't say that it has to be a common area for all the residents, and all the decks, all the terraces. That's not what it says. It has to be the residents, they have to provide for the residents. It doesn't say that, okay, you have to have a yard that's 30% for all the residents. You're never gonna achieve it. But that's why it says, when you have terraces, when you have roof decks. In a multifamily residence, if you have a roof deck, it's not going to be for the entire building. If it's 3 families, there's not going to be access through somebody's apartment to a roof deck for everybody, just common sense. Same
Mr.
thing with the
Karas,
there's
terrace.
nothing about what you're saying to me that is absolutely
You
common
just
sense.
gotta
So
read
you
it.
keep saying common sense, common sense.
Mr. Karas, if I may. So your argument based on that ordinance is that any property in any zone, right, including non-conforming. So the legislative intent behind that was that if I have a non-conforming building in any zone within the city, I can go and add outdoor space to get me to the 30%, and I don't have to go in front of the zoning board or the city.
If you're going to go into side yards or whatnot, you may need a side yard.
Right, but yeah, so let's,
But you
all
are
the sides, all the
required-
setbacks
you are
equal.
required- You're required to provide. Under the city ordinance, as stated in there, you are required to provide this for multifamily residents.
So I'm baffled by, this ordinance was adopted when?
2021.
2021.
I can understand that requirement for anything new.
Right,
Starting with a
where-
blank slate.
that's where I'm starting to go.
What I need to know is, Andy's gonna have to send me something. I need to see something that legally, that section trumps the law on expansion of non-conforming uses. Because that's exactly what he's saying. He's saying that
Or that
doesn't
it
matter.
applies.
It doesn't matter, that this controls, and no matter what the law says otherwise, you're expanding into, well, so what? We have to put this deck in there.
Right, which could mean that
No, no, no.
any
But that's-
property,
so that's
any
very
property that's not
interesting
conforming,
you said that.
Right, how is that
They're
true?
not
required-
expanding,
required to
they're just
have
living.
provide 30%.
No, no.
you gotta provide 30%,
Where-
and they don't have to come, they don't have to come in front of us for a variance.
Yes.
Right. Unless
That's
it
what
triggers
triggers,
some type
yes.
of.
Right, unless it triggers a setback,
Well, in this case, it may not trigger a setback,
but
but
it's
it's
triggering
triggering quite possibly a D2 expansion of a non-conforming
So-
structure and use.
So Jack, from the board's position, this is another, right, we're asked to do an interpretation.
Yes,
Does this ordinance fall within the board's authority to do an interpretation of that
Absolutely.
ordinance?
100%.
yes, yes.
So I think we don't have that in our packet, do we?
The-
That, the ordinance that you're,
What I could do is I can draft something.
Yeah,
If
you're
you're
gonna have to-
requesting certain.
Because you're gonna have to show me how this trumps the law on non-conforming use expansions.
yeah, so you're saying that, you're saying that
His first point.
all the case law, the Highlands case, I can't remember what it is. You're saying that ordinance would trump, if we decided that this was an intensification, you're saying it doesn't matter, that's gonna trump our interpretation that it's an intensification.
That this is that this ordinance, it's not an intensification because of the requirements of this ordinance.
No, but if, leave that ordinance aside, if the board found that it was an intensification, you gotta come back for a D.
But we also, and then alternatively, what we're saying is this ordinance deems reaching that 30% not to be an intensification.
But, okay, I'd still like to,
Go ahead.
so then, by extension of what you're saying,
You're like dancing on the head of a nail. That's,
there are maybe many properties in Asbury Park predating this ordinance that lack 30% open space. What do you expect to happen with those?
I can't say what's going to happen. I'm only concerned with the application I'm dealing with here. And my
Because you're trying,
position-
again, because you're trying to just like squeeze it,
I'm not
this
trying to squeeze
situation
anything.
into
I'm
that.
taking an
And-
ordinance in specific language, and what I'm saying is that based upon this language, adding that outdoor space as required is not deemed an intensification. It's required.
So I don't,
But if it's
so,
not, it doesn't
I don't
make,
agree either.
I don't get,
I don't see it.
it wasn't
You gotta show
existing.
me.
Off-street parking, where's
In and
that?
of itself, taken in the abstract, absolutely, it says what it says. But there's, gotta show me something legally that says that trumps the expansion on non-conforming use laws.
so here's my thought.
We have
Without
legislative
seeing that
history on
ordinance
this.
and reading that as part of the packet, and having Jack provide us an opinion, and your opinion, I don't feel comfortable.
That's all. I can get a legal memorandum out.
I-
Certainly your
myself,
board friend is
anybody else on the
requesting-
board, if they want to make a motion and continue the testimony, that's fine, but
Do you know, Donna, do you know who created or the entity?
I wrote it.
You wrote it. So you
Because
can-
part of
Thank you.
part of it was in the old ordinance. We wanted to tighten it up because of other development that was happening outside of the waterfront for new multifamily development.
So the intention is for
That we
new
weren't
development.
gonna pigeonhole them into, they gotta provide us green space around the building. We'll count decks, we'll count balconies, we'll count the interior amenity space. Roof decks, that was reasonable. And it, again, reasonable if we have a existing multifamily, I don't want to name any of them, but that needs to do some type of modifications. They're coming to the board for a site plan approval of some kind. Maybe they're doing an interior renovation, maybe they're putting on a small addition. Right, we're gonna capture that and say, oh, the new standard is open space. Show us where it is, how you're providing. And we've done that with a multifamily that came in to get an approval for a site plan. And we applied. Parts of the building that were outside the porch, the yard areas, we counted it, and that application met the standard.
And that was new construction or old construction?
That was a modification, alteration.
Of an
So-
older.
How do you see that different from this application?
Exactly.
So the thing I see about this is taking the, we're tangled with the interpretation question on the expansion of the non-conforming use. If the applicant is coming in to put a deck on their roof, apply for the variance, just like Mary Ann said in her zoning denial, you can't have this unless you get a variance from the zoning board. You come to the zoning board, we do the calculation. That goes into the question. But just like lot coverage, building coverage, off-state parking, all of the things that every use is required to meet in the code, it gets evaluated. Do you meet it or do you not meet it? If it's an existing nonconformity, it's an existing nonconformity. If it's new, you're exacerbating it in some way, then you need the variance. I mean, that's literally, right, what we do
Right.
2 times a month for a jillion years. I can't talk about prior applications as an example.
No,
Closed case, no, all right.
no, we shouldn't.
It's good to understand the intention behind it. Thank you.
But my concern is on one end, the board looks at intent, on the other end, it looks at plain language. And I'm almost inclined to agree to some degree that there may not be an expansion, but regardless, I do have a question on page 4 of the master deed, just out of curiosity to humor me. Section 8, limited common elements. Units 3 and 7 shall have roof rights to the area of the roof adjacent. Doesn't say deck rights as roof rights, although the door in question has been there, which is also concerning since it wasn't a Juliet balcony, it wasn't anything, or could you testify, was there anything blocking the door prior?
No.
Okay. Section 2 of that, Unit 4 shall have the exclusive right to use their balcony. Does anybody know if Unit 4 still has a balcony that they use?
No.
Okay. Unit 3, the
She's right back
third
there.
section, Unit 6 shall have the exclusive use of the existing patio. Does anybody else besides Unit 6 use the patio or allowed to?
I think we've all sat there.
It's 2 separate buildings.
And just out of
Yeah,
curiosity.
there's two buildings and patio.
Please, everybody, just
Yeah.
let Ms. May testify.
So there's 2 buildings and there's patio in between. Unit 6 has a small area that is theirs, which we've all sat at with them.
Okay. And then lastly, are any of these limited common elements paid for through the HOA as a whole, or is it only maintained by that unit owner as it's spelled out here in section 8?
So the front porch and the back patio, the maintenance of that?
As
that what
well
you're-
as the roofing area that's being claimed here in section 1, or subsection 1 of section 8.
So the roofing area on both buildings that you refer to for unit 7.
3 and 7, yeah.
3 and 7, that is maintained by the board. And then for the patio and the front porch, that is also maintained through the HOA and by the board.
Okay. Thank you.
So I wanted to point out, because, so the land development regulations aren't like a mandate. Like, you don't have to get everybody in town to comply with everything in the code. It only applies to development. Or when you change something about your property, and if you don't get a permit, or you're required to get a permit, you don't get a permit. So, for example, off-street parking. there are a lot of properties in town that don't have the minimum required off-street parking. We don't go around telling people to put in parking and driveways on their properties. You're allowed to keep what's non-conforming. There are lots of properties that don't comply with the lot coverage or impervious coverage standards in the ordinance. We don't go around saying, now you gotta take all that pavement out. Unless you come to the board or come to the zoning office and say, I wanna change something about my property. What applies? What parts of this regulation, this book of regulations, apply to what I wanna do? So again, we don't go around telling multifamily dwellings, where's your open space? Give us your open,
Yeah, but
you gotta change, you
Well, no,
gotta
but-
change your property to comply with this requirement. Nobody's doing that. That's
No,
not,
but I
that's not what the
also-
regulation is.
But also by the position that you're taking, you're asking us to ignore the impact and burden on a community.
Yeah, that's.
By saying this one element,
That's not a relevant consideration.
I think
excuse
my,
me?
It's not a relevant consideration. You're here to look at this particular application and the law that applies to this particular application.
Well, this application is, the individual wants to do something to their property. The city says, you're not allowed to do that to your property unless you get a variance. Your client said, well, I don't think that rule really applies. And that's why we're here for the interpretation.
Correct.
Right.
right.
The interpretation is, does that rule really apply? And the rule is expansion of non-conforming use. The thing I want to do, the city feels, constitutes an expansion.
But now in addition to that, you're asking us to interpret that ordinance
That is correct.
as well. Okay, all right. Any other questions for Ms. May?
Oh, yeah.
Any questions from the audience for Ms.? You have another witness? Yeah? Sure?
Excuse me, would it be a hardship to ask for a variance?
We have, and what we've done is we've done a bifurcated application.
Okay.
So the first part is the interpretation, depending how the interpretation will come back if we need variance relief. So we had asked for it when we submitted the application, but we split up the application to first determine whether or not we even need it. If we do, then I'll come back with proper testimony to support that application.
Mr. Karas? Oh, I'm sorry.
So either way, you're prepared to get a deck one way or the other?
I'm gonna fight for it as hard as I can.
I appreciate that. Thank you.
So, Mr. Karas, so you said you bifurcated it, right? You put in this for interpretation, but then you also put in an application. Your position is though that ordinance trumps the need for a variance, so why put in that application if you're confident on your ordinance?
I'm always confident, but not everybody agrees with me. So if you disagree with me and you're right to do that, certainly your ultimate wisdom, then I'm prepared to come in for that.
Okay.
It's called hedging your bets.
Yes, well done.
Being a Boy
I've
Scout.
been doing this a
It's
long time.
called being a Boy Scout.
It's more than a one-round bout.
I just had to point it out, that's all.
All right, so what are we doing?
All right, so I'll do a memorandum of law as requested. I'll certainly get that to your council.
Okay. I mean, me personally, I would feel better getting a better understanding of that ordinance and at least having a copy to read it
And
before.
then we'll respond.
All right, so do we have to carry this to?
Well, I really can't do any memorandums of law between now and about July 15th.
Yeah, no.
At all. After tonight, I'm hanging up my jacket.
So what's
So
our
that's-
Yes.
next available date, Marie?
August 12th? we could fit it in? Or you, but I don't, we just discussed that week, you might not be here.
What did he say, the 18th?
August 12th, the other one was August 18th.
Yeah, it should be good, yeah, the
12th you can do?
12th. Why don't we put it down for that? Jack, are you okay with that?
Yeah, I'll make it,
When's that?
you're entitled.
August 12th? I won't be
No, I
here.
don't want to.
Is there a second meeting in August or only one?
There's only one. Wait, you're saying you're not going to be here? So we wouldn't have a
It's
full
my mother's
board.
birthday.
So next,
Can
So
it
we
go
won't
to
have seven
September?
members?
What's that?
Can you go to September?
Are you okay?
What's the day we're looking at?
September.
Let's do
September 9th, we have September 30th.
let's do September 9th.
Why August?
Yeah, I mean, I'm available.
Okay.
Okay.
September 9th.
All right, I'll make a motion to carry this to September 9th
Second.
without further notice.
Andy, you agree to any extension of time we need to hear the case?
Dan, you second it?
Yeah.
So,
I-
motion, Dan second?
Dan second?
Okay.
Thank you, everyone.
Thank you.
All in favor?
I make a motion to adjourn.
Second.